Yo, got the original Lone Wolf coming at y'all with some more effery. That's the best way I can put it, you dig? But yeah, this original Lone Wolf coming at y'all real quick. Hold on one second. Yeah, so I got some more effery for y'all. Shout out to Greg Bishop, fair use, fair use. I'm not here to slander Greg Bishop, as always. We just want to take a look at the content that he was able to come across, that he's putting out. And we want to scrutinize this information that he came across and putting out. We're not here to scrutinize Greg Bishop. I'm not here to slander him. I'm not here to be mean or anything like that. I definitely wouldn't do that using somebody else's content on the internet. So fair use, and shout out to you, Greg Bishop. As always, y'all, I want y'all to listen to this shit that this dude is about to play, because again, as I said before, this is just fraud. It's fraud. I try to tear it apart every time I get. This be the reason for why I try to explain to gurus that we need to come to a common ground in regards to how we address this system. Because as long as we continue to try to fight to learn how to navigate through a fraudulent system, the stuff that they're doing in Illinois will continue, and it'll get worse. Now, we got a case that's back in front of federal court, right? And right now they're pushing for a temporary injunction to halt this having to register your firearms by January 1st, right? The cases are already going to the Supreme Court. We already know that, right? We realize that. But as of right now, the stuff is still in place. Whereas even though the stuff is going to the Supreme Court and they got cases on the docket for them to hear, the registration and all that stuff is still in place. Okay? So the Judge Stephen McGlynn down in the East St. Louis Federal Court heard arguments in regards to them wanting to put the temporary injunction in place for that particular case, and the defendant, being Governor Fred Flintstone, came forth with a motion to dismiss. Okay? So that's where we were with that. And what you're going to hear now is what transpired, okay, within, that proceeding. This is what Greg Bishop is going to start playing. So I'm going to let it play through because it's 22 minutes long. I do want y'all to hear a great deal of it. So I'm going to do everything in my power not to do a whole lot of talking in between, because I want y'all to hear this. This is an example of socialism and Marxism and Zionism and all these other things that people have been preaching and stomping and screaming till they might about. This is a good example of this. And that's one of the reasons why I don't want to, say a whole lot. Greg Bishop is going to put up stuff on the screen. If you're able to take a look at some of it, fine. If not, don't worry about it. But he'll be putting up on the screen like the actual case, different things from within the case, like the motions that was filed, and he'll be reading certain things that's actually a part of the case. And shout out to you for doing that, Greg Bishop, because that lets you know that he's somebody that'll give you the tools you need to go look it up for yourself. So in other words, the stuff that he's going to be throwing up on the screen is legit. It's so legit that you can go look at it for yourself. All right. So shout out to you for Greg Bishop. I appreciate that. Those are one of the only things that I ask about a good and fair journalist, is to just put that shit out there, man, and let the people make their own decisions. So respect to you, Greg Bishop. Much love. But without further ado, let's get started, man, because I really want you guys to hear this. Straight up, just hear this shit.
Federal Judge Stephen McGlynn says he is inclined to not issue an injunction in the request to delay the January 1st deadline, while you've also got another filing in front of the U.S. Supreme Court in the case that Dan Calkins has brought against the state's gun and magazine ban. Welcome back. It's Bishop on Air. Yesterday was a busy day for litigation against the gun and magazine ban. I was down at the Southern District Federal Courtroom in East St. Louis, live tweeting out the Federal Firearms Licensees of Illinois' challenge of the January 1st deadline, with Judge Stephen McGlynn hearing the oral arguments. So you've got that we'll review, and I'll just kind of run through the tweet that I posted. Reminder, if you don't follow me on X, be sure to follow me on X, because when there's these types of things where, you can't join a phone call or a Zoom or whatever, you have to actually be in the courtroom as a reporter with the credentials. I'm able to tweet out, to post out. I can't do live video or audio, but I can send out notes via X or Twitter. So that's what I did Tuesday after traveling down to East St. Louis to check that out. But we've also got to just briefly look at the latest filing from Dan Calkins in the U.S. Supreme Court, where he has now filed for a writ of injunction submitted to Justice Amy Coney Barrett. And we'll take a look at this document as well. We knew this was coming, but now we see that it has indeed been filed with the receipts. So we'll get to that as well. But let's go ahead and jump into the live tweets I posted from the Southern District of Illinois, where you had the case being heard, the federal firearms licensees of Illinois in front of Judge Stephen McGlynn. The case called to order. The judge had mentioned that litigants are on Zoom, but he was having trouble hearing some of them. That eventually worked itself out.
Now, also, too, guys, keep in mind, the vast majority of these people that had these cases, rather if they was in state or federal court, they're either corporations or organizations. I'm trying to establish a point to where I drill it into these people's head that it's all corporate. What they're doing is going after the securitized and corporatalized all capital letter name. This is what they're going after. They're going after their subjects. Remember, a citizen is a vessel of the United States. Remember that? Remember I showed y'all the United States Code that tell you that? Look it up. All right? This is what I'm trying to establish so you guys can understand this is all fictional. Everything they're doing is fictional as hell, and the vast majority of people don't know about it.
But he says he wanted the courtroom to be open to the public to come in and view the proceedings. There were a few people in the courtroom. There were several media, including myself, but there was only one member of the public that was in the actual courtroom. And the judge came out and said that two motions were going to be heard: a motion to enjoin the deadline, meaning enjoin means to block enforcement of the deadline. So when you hear some of these terms, and I appreciate the feedback I get from you guys, some have said, hey, can you kind of boil it down a bit more to make sure it's easily understood? And so to enjoin means to block. All right, I'm not an attorney, but just tracking all this as long as I have, you kind of feel like you got your junior law degree. But regardless, the judge said two motions were going to be considered, enjoining the deadline and also the state's motion to dismiss. We'll get to a little bit more of that later on. But the plaintiffs, they then went into their arguments as to why the motion of enjoining or blocking the January 1st deadline should be granted. They talked about proper notice. They talked about vagueness. They said the circumstances matter here because things are egregious. They said that registration, there's been a lack of notice. They also talk about the possibility of property being taken, significant jail time if somebody doesn't register and does so for items that the owner doesn't, the actions the owner doesn't take. The plaintiff said if you do something and then you don't act, there are consequences, even actions from decades ago. And that was around the idea of say somebody bought a firearm 10 years ago. And now if they don't act on something they did 10 years ago, then they're going to be punished. So that there were questions about just the due process of that. Plaintiffs noted all the firearm owner identification card holders there are and the low rate of registration. They said that was indicative of inadequate notice. But the judge went on to say that could be one thing, or it could be about protest. The judge said, should the prudent thing to be to wait and see what happens by January 1st and then deal with problems then. The state expects a lot of last-minute filers, the judge said. The plaintiffs say notification is only one issue. Then the state may expect more registration, but Illinois State Police registry rules still not complete, the plaintiff said. So they talked about...
Now, they had the J-Card meeting, what's the day, Wednesday? I think it was on Monday. And they refused to adopt the new rules that they were trying to bring up. They were trying to get certain things changed, switched around, and blah, blah, blah. So that's what I mean when I say new rules. Well, they refused to adopt these new rules. So the rules that they got already in place is the shit that's in place. Nobody understands this. This is what I was getting into when I was talking to y'all about in one of my videos, and I was telling y'all so-called law enforcement don't even understand it. They scratching their head from the Illinois State Police on down. This is going into that. Not to mention their rules. I'm not going to go into that because I want y'all to hear a great deal of this. So I won't go into the whole thing. Y'all should know what certain things mean. If you're watching my channel and this, that, and the other, you should be aware of certain things. So I don't really want to rehash that. I just really want to get into this because I want to keep it a certain time frame. I don't want to make it too long.
The earlier in the day, Tuesday, and we reviewed this in a different segment. Encourage you to go check out the highlights from the JCAR meeting. But the plaintiff said JCAR did not take up rule revisions, and with 2 weeks left, the rules still aren't finalized. So that was a major point that the plaintiffs made, saying the rules are still not final rules. They could change even after the January 1st deadline. So some clear questions as to just the process where we're at and how there's lack of clarity. The judge asked if rules have been promulgated. The plaintiffs say they have been, but due process, the plaintiffs say, requires a review of the circumstances and the consequences. And they say this has potential jail time as a consequence. Plaintiffs say that they're not taking issue with Illinois State Police, but they say the administrative process is not complete. The judge says penalties have a component of only having charges when they knowingly violate the act. Quote, this is a paraphrase, but if it's this confusing, how could they possibly prosecute? It's an interesting quote. The judge went on to say that there are problems understanding what is and what is not covered. And he says if enjoined, if the January 1st deadline is blocked, he's not sure it'll be resolved. The judge then went on to talk about the Second Amendment sanctuary counties across the state, and there are dozens of counties of Illinois' 102 counties where they have passed resolutions saying that they won't enforce gun control measures like a ban on certain types of firearms. So the judge acknowledged Second Amendment sanctuary counties. He says if enjoined, if the January 1st deadline's blocked, then he says people will point the finger at the federal court. And there'll be a blame game going on. He also asks if following the January 1st deadline comes and they address problems then, the plaintiffs say there are real consequences for those who don't comply. So they, of course, continue to double down, asking the judge to ultimately block the state from that January 1st deadline. Plaintiffs talked about consequences and what it would mean, loss of constitutional rights on a wide scale. They continued arguments saying that it's unique and it's warranted to have the January 1st deadline delayed while the case proceeds. They also talk about pre-enforcement challenges because of vagueness in this case and highlight some other case law that they had ready to talk about how judges can do pre-enforcement actions when there's vagueness in the law. The judge discussed the difference between facial and as applied when it comes to vagueness, said that registration schemes could have shortcomings and unlawful failings, but the Supreme Court of the United States, the judge...
Facial and implied. Keep that in mind. All corporate talk. It's all corporate bullshit.
Said doesn't want broad sweeping stays, which means, blocking a law from being enforced. The Scottish Supreme Court of the United States, McGlynn said, they want more narrow action when it comes to these types of issues. And the plaintiffs, they went on to say that when constitutional rights are at issue and criminal penalties apply, this makes it unique, especially with requiring the registering of parts, they said. They went on to argue that this is not an edge.
Now, keep in mind, as I said before, didn't the ATF get slapped down not too long ago where they was trying to make people prisoners and felons out of parts, pieces of plastic and all this other stuff? Well, they passed that shit through. They pushed it through here in Illinois. Keep that in mind.
Issue. It's not on the fringe. This is, central to the overall law. The plaintiffs also talked about specific items like flash suppressors and muzzle brakes and how the definitions of those cause some confusion. Then the judge asks the defendants, the state, someone has an AR-15. The stock's adjustable. If they register but don't disclose the stock's adjustable, is that a violation? The state says that Illinois State Police guidance says if a stock is attached, that's sufficient. You don't have to register the stock if it's attached to the firearm. And they say that's part of the frequently asked questions on the website. Plaintiffs jump in and say the state's answer is another reason why this is all vague, because frequently asked questions, they said, are underground regulations and not force of law.
Frequently asked questions is something that you find on the website of a business. Continue.
Standard is arbitrary enforcement with police being confused, how is the public going to comply with this? Plaintiffs argued. They said that should be grounds to hold the state to a higher standard. They say that nothing further for their vagueness arguments. So the judge then gets the defendants to jump in and have their arguments for why the state wants the motion to enjoin the January 1st deadline to be dismissed. So the state argues that various due process points. They say plaintiffs are not people, being that, it's Federal Firearms Licensees of Illinois. I believe Guns Save Life there as well, and several other plaintiffs groups. It says that they're not people and they lack standing. The state says...
Boom. Did you hear that? Did you hear it? It's all a game. Even I know that shit. And the only reason for why they can be in there making the arguments that they making is because the goddamn administrative rules and all of this stuff is being applied as a corporation, guys. This is the reason for why it's able to go through. This is the reason for why nobody's pushing Bruin. Nobody's pushing Bruin because Bruin was for the people. What they're doing is under corporate jurisdiction. I keep trying to tell people this, man. This is the reason for why it's not good to just go along with this or to insert your rights. Me personally, rights supposed to trump privileges. They claim that they do, but the way things are set up, they have you convinced that it's in a righteous fashion. Because in order to be righteous, you got to be right first. You understand? And I've been trying to explain it. I'm going to rewind it. I don't think y'all heard them. What the defendant said is an argument to the judge in response to the plaintiff. I'm going to rewind that.
So the state argues that various due process points. They say plaintiffs are not people, being that, it's Federal Firearms Licensees of Illinois. I believe Guns Save Life there as well, and several other plaintiffs groups. It says that they're not people and they lack standing. The state says that rules have been filed properly, and...
That means it's for corporations. That means it's for corporations. Keep in mind, if you're not an employee, it don't apply. This is the reason for why these people should be put in prison. Because keep in mind, like how I told you, only a small percentage of them should be brought up on charges of treason and executed. Only a small percentage of them. The vast majority of these people need to be brought up on whatever charges that fit them, that really suits what they've done, and they need to be convicted and put in prison. I'm not really for hurting anybody. I really wouldn't. I'd rather see them all go to prison for the rest of their fucking life for what they're doing. Now, this is also too a part where I hate to be like this because people say, oh, you think you know everything and you cocky and this, that, and the other. This also goes to show you that people are stupid. Also, I can't just put it all off on these judges and politicians and all this other nonsense. I can't just put it all off on them. This is the reason for why you shouldn't let the NRA fight for you. The NRA is a corporation. It's an organization that don't exist. It don't have rights. If it don't have rights, that means it don't have standing. This is the reason for why you got to know the difference between joining the NRA or any of those other gun groups. You got to understand what you're doing. Because when it comes down to these matters such as this, the NRA can't help you. This has to be done on behalf of the people. Now this helps you understand why when all of this stuff was in place and they had put temporary injunctions and stuff in place, it was only for certain people. Certain people who are part of whatever lawsuit that was going on. If you didn't pay your $200 to Tom DeVore, then you weren't one of the 7,000 people that he was representing. Now you understand why it was only temporary restraining orders for those 7,000 people and not for the whole state. But anyway, continue.
That they counter claims of insufficient notice. Also, they say it's wrong to have lower courts.
Well, hold on, y'all. Let me stop these notifications. Hold on.
Of insufficient notice. Also, they say it's wrong to have lower courts do something contrary to what appeals courts have done. Because remember, this case, at least the Second Amendment arguments, were in the Southern District Court. A Judge Stephen McGlynn issued an injunction prohibiting the state from enforcing the law. That only lasted 6 days while you had the state go to the appeals courts to appeal. And they immediately essentially put a hold on McGlynn's blocking of the state law being enforced. That's the trajectory, at least for that Second Amendment case. That's now, possibly heading to the U.S. Supreme Court. But you've got the case on trying to block the January 1st deadline. That's what was heard yesterday in the Southern District.
Now, also keep this part in mind too, guys. There's really no challenge of the brewing in the Supreme Court shit that they trying to take to the Supreme Court. There's no real challenge of brewing in it. Why? Because these same organizations and corporations are the ones that are appealing to the Supreme Court. This is one of the reasons for why we're having the stagnated process that we have. This is the reason for why you can't depend on governors and politicians and all these other people, because they're coming to you from a corporate perspective. They're coming to you from a corporate perspective. This is how they're governing. This is their rule of law. It's only the rule of law if you don't know what they're doing. This is the reason for why y'all always hear me tell y'all, now that I understand it's about the money part, it's all about money. This is what I do. This is how I do what I do in my processes of getting, different tickets or whatever. Y'all know the situation. I told y'all about my whole situation and the thing with, traffic tickets and all that other stuff. I told y'all about how the DuPage County Forest Preserve Police caught me smoking a joint and wrote me a citation. I told y'all what I did. I sent the citation back to his chief, to the chief of police, and I told him what I was going to do next. I didn't even bother with going to the clerk because I gave him a chance. It's like DuPage County Forest Preserve, really? Your police, your so-called fake-ass policy administrative officer, really? Oh, okay. I sent the goddamn ticket, the citation back to his fucking... to the chief of police with a nice little letter. I got a response back from some chick, and I think we kind of got the wires crossed because, sometimes when you send your mail prepaid, the post office be on bullshit, and they'll make it take longer for you to get to where it's going than where it's really supposed to. Them obstructing the mail, some shit they're not supposed to do under Title 18 of the United States Code. But anyway, so what ended up happening was, I ended up getting a response from them like, yeah, you didn't pay the ticket and blah, 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 this, that, and the other, before the chief of police actually got what I sent them. So that person didn't get that until afterwards. By that time, I had already got this letter from somebody else. I sent their ass a letter, and I never heard nothing else from them. To this day, they ain't sent me shit. Talking about, now you got to go to court for this citation. Now you got to da-da-da. They ain't sent me a goddamn thing. Because I told them what I'm going to do if you decide to move forward. If you decide you want to try to put something on my record and drag me into court, give me a warrant and all this other shit, then that means you insisting that I pay the citation. Well, if you insist I pay the citation, I'm going to insist that you pay the taxes. It work every time. It work every time. All you got to do is know how to defend that. Well, what do you mean, Mr. Tankersley? We're going to make us pay taxes. You cocksucker, your EIN number is this. Your DUNS number is this. What you all have done to me by giving me the citation has nothing to do with any criminal penalties. Now, when you get back to what we dealing with here with this so-called gun ban or whatever the case may be, they'll say some shit like, well, that shit right there have criminal penalties. Yeah, and it also comes with all kind of fees and fines. Now, when you add that to the fact that you cannot restrict a man's rights, there has to be something else that's going on that they're doing in order for that to seem to get ignored and they move forward with what it is that they do anyway. Well, that's the part that I'm trying to explain to the people. That's the part that I'm trying to explain to the people. Corporations and real live sentient beings, people with hearts, organs, spleens, spine, and all that can talk, that can breathe and walk and eat, they can't communicate with each other. A real live human being that's breathing the oxygen that the Creator gave us all, they can't communicate with a corporation. Okay? So that means in order for the case to even be in court, it has to be under some sort of commercial establishment jurisdiction to begin with. Because they're talking about putting some shit in place that ain't harming people. This ain't like murder. Murder and you trying to ban firearms is two different fucking things. Because with a firearm all by itself, no murder can be committed. No murder. It's the same thing with a vehicle and the whole 9 yards. You can use a vehicle to murder people. What y'all gonna do? Ban vehicles? Haven't we seen situations over the last couple of years or whatever? I said they were fake, but anyway. Haven't we seen situations where people are supposed to be getting ran down with vehicles? So what do you do now? You ban cars and hell, most electric cars are heavier than the gasoline cars they making now. So what are we gonna do? We just gonna ban automobiles and shit? No, the idea is when you got your shit set up as a territory instead of a nation, i.e. sovereign land, you can put rules in place. This is the reason why you keep hearing stuff. They even got the guts to say administrative rules. It's like, well, my God, if you follow my channel, you should know what the hell administrative rules are. The best way to describe administrative rules is in a situation where you work for a company and they got together and they sat down and they thought up some fucking rules. And then they administer them as such. No man can give another man rules that he bound to follow. No man has that authority. No man has that jurisdiction, which is the reason for why you got the motherfucking state arguing against the plaintiff, saying that they not real people. And you know what? They ain't. It's true. All of this is being done on the back of stupid ass people in Illinois, right along with corrupt people. But anyway, I've said enough. Continue.
So the state says the plaintiffs have not shown injury and offer speculation on hypothetical injuries. The judge asks, why not send an email to all the FOID card holders? And the state talks about the process, and this is kind of interesting. The state attorney there said, well, when you log into the system, and the judge says, you've been checking in on me, Chris? That was a little bit of levity in the courtroom. But the state went on to talk about how they've followed the constitutional threshold of notification by posting the administrative rules, and they argue that what's being challenged here is facially. They're
the video I did the other day showing y'all the District of Columbia Organic Act of 1871, when they rewrote the Constitution, they rewrote it to mirror the real Constitution, but the underlining part spelled something else. So in other words, you look at the Indian Civil Rights Act of 1968. Because most people don't know that, we'll just talk about the Civil Rights Act of 1968. That's what most people think that it is. But the underlining says what? No. If you go get a copy from the Library of Congress, because again, I tell this on Greg Bishop's channel. I was in one of his lives the other morning, shutting up some of his fucking subscribers. Because once you start talking crazy, I gotta bring you back in. You know what I'm saying? I gotta correct you on what you think you know. I had to tell him a couple of times in the chat, this is Indian country. I brought up the Indian Civil Rights Act of 1968. Somebody clapped back talking about, well, we understand natives and blah, blah, blah. Bruh, I didn't say natives. I said Indians. And as a matter of fact, you didn't see no people that they called natives in 1968. Or the Civil Rights Act of 1964. Now, although that one don't say Indian, it was still fought and passed on the backs of the same people that Lyndon B. Johnson signed it for in 1968. That's what makes it synonymous. So I'll go in his chat and tell him, no, man, I hate to, correct y'all on what y'all think y'all know, but the Indian is the militia. I don't give a fuck about these fake ass militias that they got set up over here that's doing the bidding of these black ops, mercenaries and all that. I don't give a fuck about that fucking militia that they got set up over here. The one they talking about, they got 30,000 motherfuckers nationwide that's ready to blow motherfuckers' heads off that look like mine. I ain't talking about them. I'm talking about the real militia. The real motherfuckers that's supposed to kick a motherfucker in their ass when they get all the way out of pocket. Nigga, this is Indian country. The only motherfucker who got real militia capabilities is the landlord. And the last time I checked, the Negro was the fucking landlord. We the only one, by right, that has the authority, the ability, and the power to correct any wrong. And notice I said any wrong. Uh-oh. But anyway, continue.
They're challenging the face of the law. They're not challenging the law as it's been applied. So the judge says standing issues are a concern, and the plaintiffs, they gave a response saying that if the standard would be to make any, the standing, the question of standing is, are they truly being injured by the law? Are they in the right jurisdiction? Are they the right person?
Did you hear him? He said in the right jurisdiction. Listen to him. Great Bishop, he a little full of shit, but I don't come here for that. Like I say, I come here for the stuff that he's actually putting out, the stuff that he really put out. You know what I'm saying? You can't trip on a man for having his own opinion or having his own word in something that he putting out. So that's why I love him. Great Bishop is all right with me in terms of what he's doing in this regard. I don't know about nothing else, but in this regard, Great Bishop is all right with me. But you heard what he just said. He said in the right jurisdiction. This is the reason for why I get out of the fucking shit when it come down to traffic tickets. I keep telling people this. This is what I told the motherfucker when the University of Illinois at Chicago campus police pulled me up. I say, what fucking authority do you have, you cocksucker? I'm on a public road. Well, I was employed by the state and I don't give a fuck. I'm on a public road. You might have been employed by the state and your goddamn paycheck may say the state of Illinois on it, but on the side of your squad car, it say campus police. You cocksucker, I'm not a fucking student. You have no jurisdiction. And what happened? They politely threw the case out. I sent the shit that I sent to the clerk, the letters and stuff that I sent. I rescinded the tickets and the whole 9 yards. I didn't go to the first court date. They sent me a nice little postcard in the mail discussing to me very politely what they might do to my ass if I don't show up at the next court date, right? So I went to the next fucking court date. Now, mind you, I don't know if they're still doing it by now because it's been a little over a year since this happened, this story I'm talking about with these particular movement violations. It's been a little over a year. I don't know if they still holding traffic court by way of Zoom, but they was around this time a year ago. That I can tell you for a fact. It's like, wow, COVID is over and y'all still holding fucking traffic meetings, traffic court by Zoom? Mind you, it ain't a cop in the chat. Not one fucking so-called fake law enforcement officers in the chat. And they just handling business as usual with traffic court. And it's like, wait a minute. Fuck the injured party part. Where's the motherfucker that wrote this shit? Why he not here? Why she not here? If no fucking body else. Don't even give me the injured party shit. We ain't even got to that part yet because we ain't even got to the motherfucker that's supposed to even told me I had to come here to begin with. This is the reason for why they always liable when they throw the case out. When they throw your case out in traffic court, the goddamn cop that stopped you is always liable, 1,000%. That's why they got bonds, people. You know, bond numbers, indemnity bonds and shit. That's why they have them. Hello? So you just heard what Greg Bishop just said. You know, the right jurisdiction. You damn right, because it matters. See, he listening to people like me. Because I be on this motherfucking channel talking about this shit. Now, I'm not necessarily saying nothing bad. Again, let me calm down because this shit, it get me heated, man, because I'm tired of people not knowing this. You know what I'm saying? It's no different than when, like how I told y'all, I had the little fender bender in the parking lot of the complex I live in. And the little, local cop came out to do the report and all this, that, and the other. And I had to check him. Bro, I'm an American Indian. Because I gave him a state ID – instead of a driver's license. I don't have one. It don't belong to me for number one. And number two, the contract is expired. I have not renewed it. That's the status of my driver's license right now. Now, imagine I don't have the plastic. They never gave it back to me. They got pissed off at me one time because they had to throw out some fucking tickets. One of them was driving with no insurance. They had me for tags, insurance, the whole 9 yards. They had to throw the shit out. They had to throw it out. This is going back to the whole thing Great Bishop just said about the right jurisdiction. They had to throw it out. No injured party, no case. No crime, no case. So they didn't give me my license back. In the state of Illinois, they could take your driver's license only if you don't have insurance or like a DUI. Those are like the number 1 and 2 things that they could take your life, like literally physically take it from you. Under any other circumstances, they write your shit up, but they got to give it back to you. So anyway, when I had this little minor fender bender in the parking lot, I gave him a state ID. I ain't got no motherfucking driver's license. The status, I don't have a piece of plastic. The status say it's expired. That means it's null and void. That means I ain't got no fucking license. I understand that whole thing about revoking your signature and all this other shit. But you literally don't have anything to revoke, literally, if the shit is expired. Did you sign something that says automatic renewal? But anyway, you can get into that angle when you know the things I know. I'd rather for people to keep it simple. But also, too, that shows you guys that there's more than one way to do it, too. See, that's another reason why a lot of y'all get confused about some of this stuff, because you don't have people on here preaching and harping that there's more than one way to do it. There's more than one way. And it gets easier for you once you know that, and especially if you're doing multiple different ways. Because when I went to court, like I said, they sent me the little postcard in the mail talking about what they could do to me if, I went to court and raised hell. But it wasn't the kind of hell that y'all may think it was. It wasn't the yelling and the screaming and all this other nonsense. It wasn't any of that. It was the I don't know what you're talking about. Can you recite your name? I tell them my first name and I tell them I'm the one that you claiming to do potential harm to. And they want to go into the whole thing about the tickets and they want to cite the ticket and what it was for and all this other stuff on what day and all this. I don't know what you're talking about. Literally, if you think it's a joke, all you got to do is be with me when it happened. I literally piss these people off because all they get from me is, I don't know what you're talking about. Okay? I never get past that because for number one, the cop don't be in the courtroom. That's number one. Now, if there's a situation where the cop actually shows up and they try to proceed forward despite your I don't know what you're talking about, then you just ask them for their EIN number that's associated with the W-9. You're supposed to already have they EIN number from the company that they work for. You see what I'm saying? They have to have licenses and permission to do the shit that they doing because they securitizing everything that you sign. They turn it into a security and they sell it over and over and over again. You have to be specialized in order to do this, especially when you set up the way that they're set up. When you're operating under duality, where, yeah, you could arrest somebody for an actual crime like murder, or you could be extorting a person for money, which don't have nothing to do with murder or robbery or a home invasion or anything like that. So it's like, what role are you operating under? This is the part where he was just talking about what jurisdiction. It's like, you damn right. Jurisdiction is everything. Keep in mind, the people in Illinois are under contract. When you sign up for the firearm card, you are under contract. This is how they're able to do everything that they do. See, what makes politicians dangerous is that when they run for office, they don't tell you this. So you're really thinking they gonna do something for the people and for the land itself, but they not telling you that they're a fucking businessman. They really work for a corporation. It could be the governor on down. And all of the legislation, right down to the local legislation in your local town or whatever, it's all the same. Those so-called aldermen or whatever you may have that's in your suburb or whatever the case may be, they're operating under corporate jurisdiction. It has nothing to do with the land. Your so-called city council and that little small town you live in or whatever the case may be, they operate under corporate jurisdiction unless they say otherwise. Now, if they say otherwise, that means they for the people. They're literally for the Constitution. But how many fucking jurisdictions in America do you know that are literally operating like that? The vast majority of them are not. The vast majority of them don't have the guts to do what the people down in New Mexico did when the governor tried to take away they carry rights. You see what happened? That don't happen very often, but that's an example of the people. To give you an example, this stuff we dealing with in these cases in the courts here in Illinois, this is corporate organizations, man, that's doing this shit. But anyway, I'm gonna shut up. Let me be quiet, man, because I want to close this out by the 1 hour mark.
To bring this lawsuit. That's essentially what standing means. So you have...
Hold on, I'm gonna go back. I'm gonna rewind it back like 20 seconds, and I'm gonna let it play forward.
Not challenging the law as it's been applied. So the judge says standing issues are a concern, and the plaintiffs, they gave a response saying that if the standard would be to make any, the standing who the question of standing is, are they truly being injured by the law? Are they in the right jurisdiction? Are they the right person to bring this lawsuit? That's essentially what standing means. So you have the question of standing that the plaintiffs say, if they followed the state's standard, it would make any challenge impossible. They compare it to voting rights challenges, saying a lack of standing would make providing a negative impossible. It's reasonable for plaintiffs to surmise what members that the members are unaware of the rules. So yeah, a little bit chunked words here, but again, I'm live tweeting from inside the courtroom. The plaintiffs also talked about how you can't undo criminal consequences on the back end, right? So this is the difference between challenging the face of a law versus challenging how the law has been applied. So plaintiffs argue that you can't undo criminal consequences on the back end and have to pay lawyers tens of thousands of dollars after an injury. So the state responds that those arguments weren't briefed and says this case is not analogous to voting rights cases. They say that the plaintiffs have...
And you know the reason for why it's not when it comes down to voting rights? Because only people can vote. Now there's a whole nother matrix when it come down to voting. Y'all know that. I told y'all I was an election judge for many years, man. So y'all know that. All right. That's a whole nother matrix to the whole voting thing, but we'll just keep it on the surface, right? We won't go down the rabbit hole. You dig? We won't go into the matrix. We'll keep it on the surface and we'll just say only sentient beings can vote, and we'll leave it like that. And that's why that's not the same. Because a corporation can't vote. But anyway.
Response to the state's complaints against a temporary injunction, and they argue proper notice has been given through administrative rule and individual notice is not required. We talked about the JCAR process, and you can go and review that segment as well. But they went on to talk about the criminal statutes. They say case law is clear, and that's why they motion to dismiss federal firearms licensees of Illinois' complaint. They say that the plaintiffs know the rules regulating highly dangerous items, and they talk about also various other case law. The state goes on to say that others not registering, maybe transferring them out of state, maybe selling them.
Here's the other thing you guys got to understand. I'm going to continue to drill it into y'all head, man, until y'all get it. The plaintiff, which is a corporation, organization, entity, fictitious entity, they're not arguing the Second Amendment the way it's applied. And it's because they're a corporation. They can't do it. This is the reason for why I keep making these videos, because they'll use this as precedent to do it throughout the rest of the country under the same pretenses. All because people don't realize that these governments are operating under corporate shit. This is the reason for why, as long as you really ain't done nothing to hurt nobody, you know what I'm saying, they don't have the jurisdiction. That's what I told Buddy about the whole thing about when I had the fender bender in the parking lot of where I live. Because he was like, it's on private property, so I can't give you no tickets or nothing. And he was like, look, just a little word of advice. He trying to be friendly, trying to be cool. He's like, look, man, your driver's license is expired. And he was like, in the state of Illinois, you could be arrested for not having a driver's license, right? And I told him, I say, look, man, I don't want to contract with the state of Illinois no more. That's why the license is expired. Because keep in mind, anything that's expired is null and void. You know what I'm saying? Now, I could leave it at that because he even admitted it within this little debate that we was having, because I had to get to the whole thing about me being American Indian, this being my land, and I ain't trying to be racist towards you, Mr. Pale Man, but you know motherfucker well this is Negro country. All right? I had to get into that with him and let him know. But even he at some point said that, you know, you are in a better position than other people. I know goddamn right I am, because I don't have no strings. It's not like my shit is expired, but before it expired, they revoked my shit or they suspended it. Where it's like, well, your shit being expired don't matter, because it was in a suspension status before it expired to begin with. So you would have to fix the suspension before you could do what I do. You would literally have to fix your suspension or your revocation, or your revocation or whatever. Like they say they revoked your shit or whatever. You would have to fix that first. With me, I had no strings. My shit ain't expired. I mean, it's not revoked. It's not suspended. It's just expired. When the contract deadline came up, I didn't renew it. That's it. But under the terms and conditions of the contract, I was fine, meaning no tickets. No outstanding balance, no suspension. So that means within the terms and the conditions of the driver's license, because it's a contract, I've kept my end of the bargain. So now that it's expired, you really, the only thing you looking at is a contract that I didn't renew. That's really all you looking at, if you know the shit that I know. But anyway, continue.
Or possibly destroying those. As to the registration numbers being low, they say complete speculation on why the numbers are low. Plaintiffs say they did argue their arguments in the briefs, and they say that because of egregious possible penalties, then they should be able to bring that challenge. The judge then went on to talk about the term assault weapon and said that that's used by some but not by others. We can't drag this out on appeal on drive-by filings. I think that was somewhat of a direct quote, but essentially he's talking about how, you know, the definition of assault weapon is a loaded term. Some people use it, others don't, and he also talked about how possibly enjoining this, you've got a lot of questions that are raised as to how long this is going to take. So he urges for swift resolution on the constitutional questions, as to what's happening here, what is and what is not protected. And he says that the Seventh Circuit mentioned only one firearm, the AR-15, comparing it to, an M16, and talking about dangerous and unusual and so on. Now, it's a military-grade firearm. Other terms we've heard, weapons of war. But he says, Judge McGlynn said the Seventh Circuit's mentioned only one firearm, but 150-plus are banned, and says citizens deserve answers, as do law enforcement.
Because that's a big deal. They keep talking about the AR, the AK, the SK platform, right? Because we know them as sporting rifles / what they call assault rifles, right? We know that. And the short barrel shit, right? We know that, right? But at the end of the day, there are tons of other firearms. Now, we ain't got to the pieces of plastic and the little pieces of metal or whatever that's on there too. We ain't got to that. We just saying outside of the SK, the AK, and the AR platform, or M16 platform, if you will, there are other firearms that's on that list.
It talks about the vagueness argument some more, argues that plaintiffs claim a lack of notice. They address that separately. They argue vagueness claim won't succeed. They talked about a high bar that the arguments require. They say that courts are not super legislators and can't block laws that are taking effect. The state argues that case law shows that we're talking about issues on the margins.
This is what's wrong with case law. This is what's wrong with it. When everything is being done under some sort of jurisdiction that's corporate, the only thing that they're doing is they're using some sort of case that was ruled in the past that they think they may benefit from or use to destroy the other person, because it go both ways, opposed to doing real work. And real work would consist of you dealing with that case and that case with regards to that case only. And not trying to use other shit Like I told y'all, when I went to take the judge and the state worker to court, when I filed my own case in court, meaning I went to sue them without a lawyer, all this other shit. One of the things that they used was a court case, and I pulled it up, and it had nothing to do with children. It had nothing to do with child protective services. And this is one of the things that they used to rule in favor of the state. Because keep in mind, I tried to take the state to court when they took my son. But anyway.
Continues on, but then the judge asks the state to argue the motion to dismiss. And this was a little bit of back and forth. Plaintiffs weren't aware that was going to be brought up. So the judge confirms that the hearing was indeed not on both the motion to enjoin the state's January 1st deadline and a motion to dismiss. It was only on the motion to enjoin. So interesting. Here's where it gets close to the end of the hearing, where the judge says that there's a mess. He says he hasn't made up his mind, but an injunction could make things messier, he said. He's inclined to deny the motion without prejudice to allow for another motion after January 1st. So when you say something, you're denying something without prejudice. That means, well, we can revisit this. If you say something,
So here's the whole thing. He's inclined to deny the motion to stop the registration till all this is sorted out. He's inclined to not block it, but he gonna do it without prejudice. So that means we get to come back at a later time and try again. And it's like, well, what else do we need to come back with at a later time and try again that don't warrant the halt to this until this is finalized? You mean to tell me we got to go further than the fact that they did this shit in the middle of the night and they just socked the person in the eye with it? You sucker punch the person in the eye with this, and we supposed to just move forward. Well, I already explained it to you guys. He's talking to another corporation because he himself is a corporation. This has nothing to do with law. This is the reason for why I tell you, when you go to read what do they call it? The Protect Illinois Community Act, or PICA or PICA, or however the fuck they saying it. When you go and read it, it's under the Illinois compiled statutes, right? But when you start reading it within the literature, it'll say it'll be lawful or unlawful, right? Well, it's like, well, again, statutes and codes contradict the common law according to Bouvier's Constitutional Law Dictionary of 1856. It contradicts the common law. So you have to ask, what are we dealing with then? That's going back to the jurisdiction part. Hint, hint, hint. If it contradicts the common law, and the common law is really supposed to be the law of the land, i.e. the Bill of Rights, i.e. the Constitution, i.e. the Republic, i.e. we the people. If that's really what the common law is, and statutes contradict that, then what in the hell are we dealing with? Now we getting into the corporate side. But anyway, continue.
You order something with prejudice, that means we're done talking about this. So he's inclined to deny the motion without prejudice to allow for another hearing. He says...
So in other words, he denied it without prejudice, which means somebody like me can come forward on the back of that and say, well, wait a minute, I'm just coming here as a sentient being. Where is it in mankind history where it says another man has a right to tell some other man or a group of people they can't defend themselves? See, that's what that without prejudice would be. That means I get to come right behind them and say what it is I just said. I come on behalf of all other sentient beings. Under the Uniform Commercial Code 1-308, I'm reserving my rights to not force you to make me compel myself to have to go along with this because I signed a contract called the FOID card, or the Firearm Identification Card. Because that's what they're doing. That's how they're doing it. Except this wasn't in the rules. This wasn't part of the agreement when you signed up for it. So that means now I'm reserving my rights. I have a right to reserve my rights at any time. I can challenge jurisdiction at any time. And the jurisdiction, by way that I choose to challenge it is that when I initially signed up for the FOID card, I never agreed to register anything. I never agreed to that I would stop buying a certain thing that I was buying prior to me signing up for the FOID card. That makes it null and void. You entered this into the terms and agreement, and you didn't give me an opportunity to opt out of it. which is something else we're going to get into when it come down to discharging debt and these creditors and all this other stuff. I ain't going to do that in this video. I'm going to do another video for that. But it's like, man, like, you got to be kidding me. You inclined to dismiss the temporary injunction till this matter is settled, but you inclined to do it with prejudice to leave the door open. Well, then that means you understand that there's some shit that could close that door that a person like myself could come right behind. But because it ain't being argued and presented in the way that it's supposed to be, this is how they're getting away with what they're doing. What makes this so important is this is coming to a state near you.
Perspective of judicial restraint, that's likely how he will go. He goes on to say, until we start getting to making merit judgments on the case, it's going to be uncomfortable and an awkward period. People want answers now, but the judge's job is to get complete record as the case moves up. You'll get my word on these one of these days on this, on the final merits. The judge went on to say that we need the people of Illinois to get answers, what's protected. Until then, we're going to have a difficult time slogging through. The judge says there are going to be a number of applied challenges and continued confusion about registration, and the Supreme Court of the United States has indicated that prosecutors should not enforce unclear laws and rules. Again, I think that's important. He said that the Supreme Court of the United States has indicated prosecutors should not enforce unclear laws and rules. He says that they're going to be exploring this further on the merits of all of this in January and February. Plaintiffs argued guns are one issue, but it's the parts as well. Then they, talk more about, plaintiffs asking for clarification on possible relief from the Supreme Court of the United States because there are pending challenges there as well. So after the hearing wrapped up, the judge did say to expect a ruling promptly, but he reiterated that he has not made up his mind, despite clearly in some of those tweets saying that indeed they are going to likely not block the state's January 1st deadline, saying that could make things messier. And while all that's playing out, you've got the U.S. Supreme Court getting another fight.
Here it is. That could make things messier, but they the ones that started this. So you're going to go along with the people who made the mess. Think about that, y'all. Think about the Marxist socialism bullshit in that.
This time from State Representative Dan Calkins, who already had a different filing, and those filings were, ultimately about the Illinois Supreme Court's ruling on this and the lack of these individual justices that received campaign donations from recusing themselves. Well, now Dan Calkins has a motion.
Now y'all understand why Dan Calkins took the approach that he did opposed to what Thomas DeVore was talking about. Thomas DeVore case got shut down because Dan Calkins got to do what he doing first. He jumped the motherfucking gun and went ahead of everybody. And there's a reason for why he did it. And back at the time, Thomas DeVore, who was an attorney, pointed it out. That this is what this guy was doing, right? Now, it didn't make sense as to why he would do it if allegedly he was on the same side, meaning to get it shut down. But the reason for why he jumped forward and took his case the way he did it is because, number one, Thomas DeVore was arguing equal protection, right? Which is constitutional. I can give him credit for that. He was arguing the fact that you can't carve out certain people. His whole case was geared around the people, meaning they were saying law enforcement, prison wardens, private security guards, like let's say you got your perk card or whatever, and you go work for a private security firm where you stand in a grocery store armed and shit, just, people like them, they exempt from all of this. Well, one of the things that Thomas DeVore was trying to argue in his case was that per FOIA request, there's a lot of these people that's on the exemption list that don't have any training of any kind. And he argued, well, that's, unconstitutional under equal protection, which it is. And it made perfect sense by way of FOIA. Once he pulled the FOIA, it was over. So with this guy, Greg Bishop talking about, this Dan Calkins guy, he jumped out and took the lead and put himself in a position to where his arguments were heard first. But nothing in his arguments were about what Thomas DeVore was talking about, which was the equal protection under the law. That requires people. Okay? because they exempted certain people. Now, granted, they have jobs like police officers and this, that, and the other, but they're still people. Same thing with the prison wardens and all that. They're still sentient beings. Ain't no corporation running the prison. It's the men and women that run the prison, even though the prison is a corporation. Y'all already know that because they privatized. Prisons are corporations. So how is it that this ain't corporate jurisdiction what they doing? You see what I'm saying? So Thomas DeVore case was never heard properly. What the judges all did was say, well, since Dan Calkins and, his legal team and that, they got their case where they at now and they doing what they doing now, we going to consolidate everything and we going to do this, that, and the other, and we not going to hear your case on an individual case basis. Like how everybody was trying to do in the beginning, because don't forget about the Naperville case. So again, I'm pointing all this out, man. I'm going to end this at the 1 minute mark. It's all ran by corporate jurisdiction. And that's what's got us in this. What make it important is the fact that they're going to do this everywhere in the country, man. If people don't stand up and understand what jurisdiction is and what it means. Like how I said, I'm going to end it like this. The FOIA card is how they're able to get away with this. Because in order for you to even qualify for a banned firearm, you got to have a firearm card to begin with. You see what I'm saying? It all starts there, with you contracting with the state. Keep that in mind. That's how they're doing it. The part that you need to understand is that you have a right to reserve your rights. I didn't sign up for what they're doing now. I didn't sign up for that. I understand that I signed up for the FOIA card, but at the time when I got mines, y'all wasn't doing all of this. And then you didn't give me an ability to opt out of it. That's the other thing they're doing. That's a violation of your rights. You're literally being kidnapped and forced. This is sodomy. You're being sodomized when they do this in the manner that they're doing it. You're being sodomized. It's like they're literally sticking something in your orifice. Literally. That's like what it's like. Because you change these terms and conditions. It's a contract nonetheless. Forget about the fact it's with the state police and the governor and all. Forget all of that. It's a contract. And for the people who so-called had this contract in place, i.e. the FOIA card, prior to them doing what they did January 10th of this year, those people have a right to say, well, no, wait a minute now, I didn't agree to this. I didn't agree to this. So that helps you understand why the judge talking about, well, if I do deny the temporary injunction to have the stuff registered, I'll do it with prejudice. Not without prejudice, but with prejudice. I mean, he said, I'll do it without prejudice, excuse me. Not with prejudice, because that means that you can't come back down the road. He said, I'll do it without prejudice if I do strike it down. That means somebody like myself or somebody who understand that people who sprung from the soil, people who come from their mother's womb, they have rights. Corporations do not. So look forward to the judge striking it down. Because what the defendant put up, what Governor Fred Flintstone legal team put up is the truth. The plaintiff don't have standing because they're a goddamn business. I hope y'all learned something in this, man. I'm up out of here, man. Much love to y'all.
For writs for an